Good morning and welcome to a very special moment for us. I realized that I attended my first annual MAA conference 20 years ago, which is a great moment to also celebrate two very special academics and professionals and arbitrators as part of the ITA, the Institute for Transnational Arbitration, Preserving Perspectives, International Arbitrators in their own words. My name is Krina Baltak. I'm the chair of the Academic Council of the Institute for Transnational Arbitration, the ITA. I'm associate professor in international arbitration law at Stockholm University and a former MUTI. The ITA Academic Council's interview project, Preserving Perspectives, International Arbitrators in their own words, is important and wholly unique among projects hosted by international arbitration organizations worldwide, in that we interview prominent international arbitrators, international practitioners, and record the stories of their lives and careers as they themselves tell it. Afterwards, the videos of these interviews are memorialized forever on the ITA's website so that future generations of international practitioners and arbitrators can watch and learn from them. Today's interview, as I said, is special, also because it is the first one during the Willem Sivis International Commercial Arbitration Moot. And to mark this special moment, we have, as I said, an exceptional interviewee, who will be properly introduced later, Professor Ingeborg Schwenzer, Professor Emerita of Private Law at the University of Basel and international arbitrator. Professor Ingeborg Schwenzer will be interviewed by Professor Edgardo Muñoz, Professor at Universidad Panamericana Guadalajara and member of the Academic Council of the Institute of Transnational Arbitration, member of the Advisory Council of the CISG, correspondent in Mexico of UNIDRA, and member of the ICC Commission. Professor Muñoz holds Master of Law degrees from University of Liverpool and University of California, Berkeley, and a PhD from University of Basel. I would like to acknowledge, of course, the support of the Moot Alumni Association. Thank you very much for making this possible. Thank you, Schoenherr, for hosting us and also for making this possible. Many thanks to the ITA staff, including the ITA Chair, Professor Chip Brower, ITA Director T.L. Kabic, ITA Assistant Director, Dr. Darya Sharkova. Now, without further ado, the Academic Council of the Institute for Transnational Arbitration is very pleased to present our Preserving Perspectives project interview of Professor Ingeborg Schwenzer, interviewed by Professor Edgardo Muñoz.
Thank you very much, Professor Krina Baltak. Welcome you all. Welcome you today here. 1 year ago, this date, but not 11 April 2024, but on the start of the moot 1 year ago. During the opening event, there was a band playing, and the leader of the band, the leading voice, stopped for a moment and said, and now welcome to the stage someone that doesn't need an introduction. And if you haven't heard about her, you shouldn't be here. He mentioned that. And of course, it was Professor Ingeborg Schwenzer. And Professor Ingeborg Schwenzer, if we have a look at what ChatGPT tells us, is something probably you already know. She is now emeritus professor at Basel University. She is adjunct professor and has been adjunct professor at several universities, to mention some, Hong Kong and Brisbane in Australia, also Bonn University. She has written and published more than 200 articles on the law of obligations and contracts, arbitration, family law. She is the editor, co-editor, and leading author of the CISG commentary that you all know, and with Oxford University Press, and also of many of his translations, five languages. And besides that, she is a very active arbitration practitioner, legal expert, and lawyer. But that's something we could find as an answer in Google, ChatGPT. But today, we have the chance, this is a historic event, I believe, to learn more about the beginnings and the development of one of the greatest minds in international contracts. And of course, it's an honor to me. I'm very grateful for this opportunity to interview our star of today. And before I start with the questions, probably I should give you the floor, Ingeborg, say a few words.
Thank you very much, Edgardo, for this kind introduction. Good morning, everybody. Let me thank the organizers, ITA, MAA, and the host, Schwenzer here, for giving me the possibility to be here in this wonderful surroundings. I have spoken at MAA conferences, I don't know, 10 or 12 times, not only here in Vienna, but also in Hong Kong. But I have, before we start the interview, I have to confess something to you. I was never as nervous as today, because giving a paper on the CISG or on arbitration is one thing. That's my profession, but talking about myself is another thing. So I'm happy to be here and to share with you some thoughts also that I developed during my life. And yes, welcome everybody.
Thank you, Ingeborg. And believe it or not, Ingeborg had your age at some point. And let me start with your beginnings, Ingeborg. Your academic journey began with studies at the University of Tübingen, University of Geneva, Freiburg University, and culminating with an LLM at UC Berkeley. How did this diverse educational experience shape your perspective on the law and your later career?
Yes, actually, when I moved into comparative law, I was even younger than you. I was about 18 or 19 years old, because already at the beginning of my studies, I realized that I was bored by just studying domestic law, in that case, German law, a very dogmatic law. So for my second year, I decided to go to Geneva and get some more or less international flair there already. And in Geneva, I met a professor who encouraged me and motivated me to become a professor myself. So I thought, well, what do I want to do? Okay, I want to do comparative law. I already decided during my second year. So I decided, okay, I go to Freiburg in Breisgau, where there was the eminent scholar Ernst von Kemmerer, and he was pivotal for my whole academic life. So in Freiburg, I took a seminar with Professor von Kemmerer, and well, I was very much impressed when especially male students started to talk about the intricacies of German dogmatism. Von Kemmerer, he was short in height, but he was a great man. He stood there, or he sat there and frowned and said, when does it become practical? And this sentence has led me through my whole life. My whole legal thinking is based on this sentence, when does it become practical? And then after von Kemmerer accepting me as a PhD student, I went to Berkeley, as you mentioned, and in Berkeley I met another great scholar, great man, and that was Fritz Kessler. And Fritz Kessler was a very generous, very kind man, and the way he treated students really shaped my way of teaching and treating students. just to give you one example, we had a dead week before the exams to prepare for the exams. And during the last lecture before the dead week, he went to the blackboard, wrote down his telephone number and said, if you have any questions, call me until Saturday 6:00 p.m. and ask them, because it's not good if you go into an exam having open questions. Actually, I imitated this. I found it so generous, so kind towards students who are struggling, you know. So I didn't give them my telephone number. I told them, you know, my email address. Just send me an email. Every email that is sent to me by Sunday 6 p.m. will be answered, and you don't go into exams with any open questions. So he was shaping my way of treating students. And actually, what is interesting, both Ernst von Kemmerer and Fritz Kessler were assistants to Ernst Rabel. The great Ernst Rabel, who was the founder of modern comparative law, the founder of the CISG in the 1930s. Thus, I may call myself a double granddaughter of Ernst Rabel himself.
You certainly have the CISG pedigree then. and I think we all can witness that you take a very practical approach in your many articles and books that have populated the CISG community, and that also you are a very devoted person to your students. And going back to Freiburg, you did your doctoral thesis there on the cellular limitations of liability, right? For defective goods under American law and German law. What inspired this topic, and how this shaped the way you would approach later on your research focus on comparative law?
Yeah, as I already mentioned, I had decided to become a professor, and I had decided that I would focus on comparative law. Thus, it was clear to me that I would take an LLM in the United States right after my first state exam. I was 22 or 23 at that time. And the US thesis for the LLM should be the basis for my PhD under Ernst von Kemmerer. And I was always very aware of vulnerability of certain groups of society. Also not only vulnerability of certain groups of society like consumers in that case, but also vulnerabilities of certain groups of people in the global south, for example. At that time I had already spent 3 or 4 months in South America with a scholarship by the German government, writing a project on the reform of education in Peru. And so vulnerability was always a theme for me. That is why I turned to questions also relating to consumers. And there I suddenly realized there's such a sharp difference between B2B and B2C relationships. That was not, at least in Germany, at that time in the 1970s, that was not a subject yet, that you really have to separate B2B relationships that are based on party autonomy, on freedom of contract, and B2C relationships where you have a vulnerable party and where you have to protect this vulnerable party, actually.
Interesting. Yes, Ingeborg, you are a dogma breaker, as we can see in your writings, but you are also a barrier breaker, and in this regard, throughout your career, you very often were among the first women in many positions. You were the first woman who got her habilitation, which is a German degree to become a professor in Freiburg University. The first woman to get a full professorship in all Germanic speaking countries. And naturally, you were the very first female professor in Switzerland, the very first law professor in Switzerland. What challenges did you face breaking these barriers?
Well, it's quite interesting. When I was young, I didn't realize that there were so many discriminations against women. With pretty good results in all of my exams, I took it for granted that I achieved all the goals that I had set for myself. I didn't have a female role model, they just didn't exist at the time, or a female mentor, as I now hope to be one for many of young women, also in the MAA mentorship program. I didn't have anything like that, and probably I did not miss it. I didn't think I would need it. It was only with hindsight that I realized the sharp discrimination, especially in the 1970s, especially in Europe, in Germany, in Switzerland. It was better already at that time in the United States and a bit in France, but it was just terrible in Germany and in Switzerland. Well, since then, during the last 50 years, things have changed, albeit not enough in my view. Yeah? In Switzerland, we now have about 20 to 30% female law professors. It's still worse in Germany, actually. For example, if you look, I know Freiburg. Freiburg has 27 professors, out of which only 4 are women. In Heidelberg, it's 3 out of 23, I think. None of them in private law or in criminal law. They are all in public law. So I think it's still a situation that is unbearable, and I'm afraid it will not get better. Having regard to the fact, and I'm shocked, I have to tell here, that many corporations, not only in the US, but also in Europe, now have abolished their DEI programs already. Yeah? And so I think the situation will not become better for women, rather it will go down again.
Well, that doesn't sound like very good news, but I think we have to keep working from our side in diversity and making progress, especially gender diversity. Yeah, and I would like to turn to your expertise and to talk about a topic that few know about it. You are also an expert on family law, and you have researched and published extensively on this topic, and it has been very influential in many respects what you have done, to the extent that the German Constitutional Court, Supreme Constitutional Court, and also the legislator have followed your suggestions with regard to family law reform.
Yeah, indeed. My habilitation, Edgardo already mentioned it, it's the second book you have to write in Germany to become a professor, was on family law. And the title represented my legal thinking in family law, and maybe not only my legal thinking in family law, but I think it's even a theme of my life. The title was From Status to Relationship. For me, that was, status is not important. It's not important whether you're married or whether you come from that and that family. It is important what you are really living. The real relationship that you are living in life, that is what counts, and not what your status is. In family law, my approach was always threefold. It was, as I'm a comparatist, it was comparative. If I had confined myself to German law, oh gee, yeah, I mean German law was, I would say the German and Swiss law, they are the last in line to do any reforms on family law. So I was very much looking to countries like Australia, New Zealand, England, also France for certain aspects. So always comparative, but also interdisciplinary. Actually, I have an education as a psychotherapist. So I tried to combine the two. I had one year listening to sociology and psychology, and then taking into these aspects into my legal thinking. So the second approach was interdisciplinary, and the third one was inspired by Ernst von Kemmerer. It was bringing together theory and practice. So I always ask myself, how does it work out? And especially in Switzerland, I founded several institutions like, I did a commentary on family law. I founded a journal on family law. I founded an institute center for family laws, family studies, not family law studies, but family studies, which brings together practice and theory and the interdisciplinary approach. So actually, until about 2005, family law and international or contract law of obligations took more or less the same place in my academic life. And around 2005, I published a model family code on a comparative basis, actually my vision of family law for the future. You can download it from my website. And well, after that, I decided, okay, I've said everything I have to say in family law, and now I exclusively turn to international commercial law and arbitration.
That's fantastic. Great. It calls my attention your psychotherapist aspect or prompt. Do you think that has influenced, for example, your approach with regards to weaker parties in sales contract? For example, it came to my mind your famous Nobel-Mont rule and the buyer's obligation to examine the goods within a certain period of time.
I think my tendency, my concern for weaker parties was much earlier. That dates back till I was 17 or so. And maybe also that I got the education in psychotherapy was also linked to that. It may have reinforced my thinking in that direction. Yeah.
Fantastic. So, what drew you initially to the area of international contracts, and in particular to the CISG?
Well, that was very early, and that was also linked to Ernst von Kemmerer. That was in 1978, 2 years before the Vienna conference. I was first dealing with the CISG, and the background was Ernst von Kemmerer was the chair of a committee of German law professors that advised the German government on treaties in international private law. And in 1978, these were the drafts on the CISG. And as Ernst von Kemmerer already had retired, he hired me as his assistant, and this group discussed the drafts of the CISG for more than 2 weeks. And I was in charge of writing the minutes. And they were very voluminous. I think I wrote something like 300 or 400 pages of minutes about the drafts of the CISG. That was my first contact with the CISG 2 years before the Vienna conference where it was agreed upon. And then I was assistant at the chair of Peter Schlechtrim, and Peter Schlechtrim was a member of the German delegation at the Vienna conference, and when he came back, I helped him with his first book on the CISG. And then in the 1980s, work on the commentary already started, and its first edition was published in 1990, and I was already authoring some articles, not as many as recently, but some articles. And so that's how my life on the CISG started. So if I look back on 45 years of the CISG now, since 1980, I think we can really say that the CISG has been a worldwide success. And not only, or maybe not because of its 97 member states, the fact is that in many countries still parties who do not know the CISG opt out from the CISG, thus the practical importance may be less than it could be. But I think the CISG really has become the lingua franca of international commercial law. And it has served as a blueprint not only for international unification of contract law, like the UNIDROIT principles especially, but it has served as a blueprint for many domestic legislators. During the last 20 years, there have been many legislators, especially in civil law legal systems, reforming their civil codes, and all of them except for one, and that was Turkey in 2016, but all others have based their reforms of contract law on the CISG. We will maybe later talk about that when we come to global sales and contract law.
Correct. Yeah, but for now, let me focus on your role as a mentor and as an educator, where you have been fantastic. I must say, you have supervised many successful scholars and practitioners. More than 10 former assistants of you are now professors around the world, including myself. Many are partners in leading international law firms and also prominent judges and arbitrators. Actually, you are very maternal with all of us, in the good sense. You care about us and you have guided us over the years. And I'm not sure if you are aware, but we call ourselves the Schwenzerians community. And there is a gathering every year. So what do you consider the most important qualities to foster in young legal minds?
Probably what I have myself, and that is curiosity and its openness. Well, in all legal systems, still at law schools, you are taught domestic law, yeah? And there are many law students who never encounter any international question during their whole law studies. So I think that's fine if you decide to become a lawyer in your domestic administration and you're issuing, let's say, certificates or licenses for regional housing projects. Well, that might be a nice profession too. But there is a world elsewhere. And this world elsewhere is fascinating. And you have to be curious how other legal systems deal with the same factual problems. And you have to be open to different solutions. You have to be open to other cultures, to other legal thinking, and to other cultural thinking. And I think it is comparative law that really fosters the characteristics that you need as an international lawyer.
Yeah, and do you think that the CISG can be used as a tool to foster this critical thinking and curiosity?
Yes, I'm very much convinced about that, because if you take the domestic starting points, you will very often find that the legal systems, especially civil law legal systems and common law legal systems, are coming from two diverging poles. Somewhere they meet in the middle. And very often these domestic solutions are historically, can be found historically, and many legal systems, domestic legal systems, are still based in the 19th century. If you take, for example, the law of obligations in Switzerland, Germany has revised its law of obligations, but not really. It's still also based in the 19th century, in dogmatism of the 19th century. And these domestic legal systems are concerned with domestic conflicts. Yeah, they are not fit for international, for cross-border conflicts, and they are not fit for the questions that arise today with regard to our modern commercial world. And it was, as I already mentioned, based on the seminal works of Ernst Rabel. It was first UNIDRA who took up the work on unification of sales law, and then UNCITRAL was founded especially to take over the conventions under UNIDRA and to make a global convention on sales law. And I think UNCITRAL or the people who did that really achieved great compromises. The CISG offers, in most cases, I would say 95% of all questions, the best solutions that you can find from comparative law. And thus I think teaching also the CISG, if we start from the diverging poles in civil law and common law jurisdiction and tell the students what are the reasons why we have the mailbox doctrine under English law, why we have that, and then find out, the CISG found this compromise, and that is the basis for. I think this leads you to a deep, true understanding of contract law and to a critical legal thinking that is beyond anything you can learn under domestic law.
And you need that uniform law treaty, uniform law instruments.
Yes, I think you need it, and you need it in the practice of international arbitration, because you have to relate to opposing counsel who probably comes from a totally different jurisdiction. You have to relate to arbitrators coming from different jurisdictions, and by knowing a comparative background, you are able to understand the legal thinking of your fellow arbitrators, your fellow counsel, and you are able to communicate, you are able to adapt yourself to their legal thinking and to make you understood.
Yeah, fantastic, fabulous. And let's now talk about the Bible. At least the CISG Bible, or religious book on the CISG, according to your own beliefs. The Schlechtrim and Schwenzer commentary on the CISG has been hailed as a source for practitioners and scholars worldwide. What do you believe has been key in its enduring relevance and widespread adoption across jurisdictions?
Yeah, I think many commentaries. In many commentaries, you find the domestic legal system reflected in the comments by the authors. From the very beginning, we tried to have a true comparative approach to the questions under the CISG. And I think that makes it workable in practice, and I also think this is a good basis as a scholarly writing, and I think that's part of its success.
You mentioned before that the first edition of the commentary was done by Peter Schlechtling, probably before by Ernst von Kammerer. How did your collaboration with them shape your work, and what were the most significant challenges in updating it over the years? I'm talking about the commentary, of course.
Yes, well, I already mentioned Ernst von Kammerer was really pivotal to my development as a legal scholar, and especially for my academic development as a CISG scholar. And the work at the chair of Peter Schlechtling reinforced this approach, as we always worked on a comparative basis. I already said I helped Peter Schlechtling with his first book on the CISG. I also helped him with a chapter in the International Encyclopedia of Comparative Law, so it was always comparative work. The challenges that we faced with the commentary was not only updating the commentary, having a look at all the member states and the case law and scholarly writing in other member states of the CISG, but I especially was always focusing also on the development of domestic contract law in different legal systems. Like, for example, I commented Article 74, the provision on damages, and there you will find a discussion of the question of disgorgement of profits, which was coming up about 10 years ago or so with an English decision, but then discussed in many other legal systems. And I'm convinced the CISG has to embrace these developments in domestic legal systems, because if the CISG says, oh no, we are not concerned with this question, it will leave the decision of this question to the domestic legal systems. Thus, it will lose its international character, it will lose uniformity, and rather sooner or later fall into oblivion.
Indeed. Uniformity is an asset for international trade and globalization. And I mean, probably the answer to this question is obvious for all of us, but it's always good to ask the question to the author. But do you think that the CISG commentary has been influential on how judges and arbitrators apply the CISG, work on the CISG?
Yes, I dare to say it has been influential. It is very often cited, and I want to give you one example from my own experience. As I said, in the first edition, I was only commenting 2 or 3 articles, and then I took over. And when I took over Articles 38 and 39, the provisions on examination and notice, I sat down and there were already some German court decisions, also by the German Supreme Court, stating that notice had to be given after or within 3 to 5 working days after the delivery of the goods. So examination and notice were 3 to 5 working days. This was exactly the German approach to this under the German Commercial Code. So I was asked to comment on this and to find a to find a solution. And I was sitting there, and I knew from my comparative background, well, I can never, and I didn't want to sell it to anybody. So, but I could never sell it to lawyers from countries where there is no duty to give notice at all, many countries, or other countries like, for example, under the Uniform Commercial Code, where there is a duty, but where it is interpreted very generously, like 2 years are okay in giving notice. So I was sitting there at my desk pondering, asking myself, well, what should I suggest? Yeah. On one side, I want to convince the lawyers from these countries that do not know a duty to give notice, and on the other side, I have to convince the German Supreme Court, stubborn board of judges. Okay, so I pondered and I came up with it was just rule of thumb, yeah? And I said, okay, I say 4 weeks after the buyer has noticed the non-conformity. So you have the delay for examination, yeah, which can vary according to the circumstances. And then if there are no other special circumstances, then you have 4 weeks to give notice after having realized the non-conformity. Okay, and the German Supreme Court bought it. So did the Swiss Supreme Court, and in many other court decisions around the world. And one scholar, Camilla Barsch-Andersen, who is now a professor in Australia, was formerly in Denmark, she called it the so-called Noble Month. So the Noble Months made it also in arbitration. It is cited. So I'm a bit, I'm happy that that happened. And there are other things where I was very happy in 2000. I think it was 2006 or so, when for the first time, I think nobody had mentioned it before, I was discussing ethical values in international sales contracts. Peter Schlechtrim actually was not amused. He told me, well, we all know that the business of business is business, but not ethics. Okay, so I think nowadays we all know ethics is a very important feature in sales contracts. So is sustainability, and it's not only about ethics; it's about economics. Yeah. It's an economical question whether in the supply chain there has been sustainability. If we look at all the supply chain liability that we now have around the world.
Should be happy and proud of these two contributions to scholarship and to practice in this, because they are practically applied. Both of them, the Noble Month rule and the rules on assessing the conformity of the goods through the lenses of ethical standards, have become famous passages in the Bible. Yes, indeed. And talking about the commentary, it's been translated into over 5 languages. So, a while ago you mentioned that English is a lingua franca, and the commentary main edition is in English, but why do you think that it was necessary to also publish the commentary in other languages?
Yes, indeed, it was one of my goals, unfortunately. Yeah, I should be 20 years younger now, then I could have more languages. It was always my goal to have the commentary translated into as many languages as possible, and the background is court decisions are still very influential for the development of the CISG because they are published. Arbitral awards, most of them are not published. So we need we have to convince the courts, and we have to get uniformity of application and interpretation among the courts in the member states of the CISG. And the problem is that judges in domestic courts do not research in English. Yeah? They have their law libraries at the courts, or nowadays they have their databases, and the databases are in their own languages. And they don't have the time, and they are not fluent in English to research, for example, the internet for English-speaking commentaries or the like. This is true for all countries. Take Brazil, take Germany. If you take a German Supreme Court decision, they cite only German scholarly writing and German case law. There's no English-speaking source with the German Supreme Court. So my idea is I have to give the domestic judges a tool in their own language that is the same as the tool that the US lawyer has, the English commentary, or as the German counsel has. So that promotes uniformity. And I think that's the only way. Certainly in arbitration it's different, because in arbitration English indeed is the lingua franca, so for arbitration we need only the English commentary.
Yes, can we count the languages being translated?
Edgardo, you were the first to do it in Spanish. We have it in German, we have it in Portuguese, we have it in Turkish, we have it in Polish. It's still in the making in French and Chinese. We will soon have it in Japanese, published in Japanese, and well, it's still in the making. Well, that's a different story. It has been ready in Chinese, but it's difficult.
That's really an accomplishment, because obviously translations are usual in novels, literature, fiction, but not in legal literature. So congratulations for that, Ingeborg. And do you think that the commentary has a role beyond courts and arbitral tribunals, for example, in education?
Yeah, if the students are engaged in comparative law and in international contract law, then yes, I hope that the commentary helps them to have a comparative approach and to contribute to further uniformity of the CISG in the future. However, we have to realize that there are parts in the world, especially in the global south, in Africa, but also in Asia, where there are the faculties cannot afford to buy such a commentary. Actually, I've been in countries where they cannot afford to buy any books. The students don't have any books. They have the scripts of their professors that they are teaching from, but that's all they have. And thus, well, the commentary cannot help them. But I'm very fortunate. All of you know Louise Barrington, the director of and founder of the WIS East in Hong Kong. And Louise has initiated a capacity building program with the help of arbitral women and formerly with the help of US aid. And I have been privileged that Louise asked me to participate in such capacity building programs, for example, in Cambodia, Myanmar, Nepal. And there we are teaching for 2 weeks. We are teaching students from the whole country. They are coming to the capital of the city, of the country. And we are teaching them in CISG and in arbitration. And it's just wonderful when you see these students flourish during these 2 weeks. And then I usually, when it's beginning of October, and when the problem comes out, I sit down with them And then we search the internet, yeah, and we look what can we find freely accessible on the internet, because these students do not have the money to access Kluwer arbitration like yours in your law school. So they really have to rely on the internet. And for example, therefore, I published all my articles immediately on my own website, so they are accessible for all students around the world.
That's fantastic, Ingeborg. I think your generosity is priceless in that regard with these students. You have a different book, an additional book to the commentary, which is the Global Sales and Contract Law, which has been praised by his comparative approach and its extent of review of many different legal systems. And the question is how this book has, what are the practical challenges you have faced while doing this fantastic and big work about the law of contracts in different jurisdictions?
Yes, global sales and contract law has really been a global adventure and endeavor. Actually, at my chair in Basel, when we prepared it, it was around 2010, we had up to 25 assistants coming from Europe, Latin America, Africa, Sub-Saharan Africa, Middle East, Eastern Europe, Central Asia, China, Australia, so really the whole globe. And they researched along a general scheme, a general structure. They researched about 60 legal systems. And so it was a truly comparative and fascinating endeavor. And the assistants were not only supervised by me, but we had correspondents around the world. There were many colleagues in Japan, in China, who supported me and who answered the questions of our assistants. So I think for everybody, for the assistants, but also for me, it was an incredible adventure and experience, because each week we discussed the questions that were to be done during the week on a comparative basis. And each of them wrote their actually PhD thesis on these questions in Latin America, for example. And well, in the end, out of this, it was many of them became professors around the world, like yourself, Edgardo. You already mentioned it. You were part of the team, and I thank you for that.
Oh, thank you, Ingeborg. It was, as you said, a life-changing experience. Yeah, and it's now in the second edition, right? Can we still find something new in the second edition?
Well, first, thank you, Edgardo. Edgardo is now the co-author of the books, and thank you very much for assuming this task of the second, and I hope of further editions, maybe. It was 10 years between the first and the second edition, and a lot of developments had taken place, especially in civil law jurisdictions. Many legislators had revised their civil code. Just to mention a few, Germany was already before, that was in 2002, but after 2012, when the first edition was published, it was, for example, France, Japan, China, Argentina, Hungary, Romania. So many changed their civil codes based on the CISG. So all these developments had to be incorporated, as well as new case law and new scholarly writing. And it was a fantastic endeavor, and Edgardo had the idea to announce a summer internship with me via LinkedIn to find assistance for this project. And we had something like 500 applications.
Wow.
And in the end, we had more than 170 assistants working in groups and 12 editing assistants. And again, we had 30 correspondents, colleagues of mine around the world who supervised the work they had done. And yeah, I think it's a real good second edition.
Yes, it was. The timing. I mean, despite of the many bad things that happened during the pandemic, we were lucky that many students and young scholars were looking for online internships. It was just at the right moment where everyone was willing to volunteer to do this summer camp and internship, helping us with the global sales and contract law. But what would you think would be, or how would this book look like in 10 years if you were to write a new edition of both the commentary and the global sales and contract law book?
Well, I'm afraid that the time for unification of private law is already part of the past. I think further unification of private law does not have a future if we look at the political developments, not just during the last weeks, but already before. Many countries have become very parochial. You can find a homeward trend with many domestic courts. And already in 2012, actually, Switzerland suggested to UNCITRAL to further unify contract law on the basis of the CISG and on the UNIDROIT principles. I was part of the Swiss delegation in New York at UNCITRAL when we made this proposal, and we got a huge support from delegations that never took the floor, like the Japanese delegate supporting us, China, Europe, Scandinavia supporting this Swiss proposal. But there was fierce opposition by the leader at UNCITRAL, and the leader are the United States. And without the support of the United States, unfortunately, nothing happens at UNCITRAL, and there are many delegations following suit if the United States are not in favor of something they would never support it. So already in 2012, unfortunately, this endeavor was doomed, and I think today there would be no way to have the CISG anymore, or to have any further unification of contract law. Now we are focusing on petty things like, I don't know, but not the whole picture, not the whole picture of contract law.
So let's hope that these turbulent times go away soon. And if you allow me, let me turn to a nicer topic, the Bismuth. The Bismuth, the CISG, and you. So, obviously the mood revolves around the CISG, right? It's one of the two main issues that are discussed every or two of the four issues that are discussed every year. How do you think that the CISG enhances the students' training preparation for arbitration and substantive law in general?
Yeah, let me remind everybody of the late Eric Bergsten. It was his vision. He was officer at UNCITRAL while the CISG was discussed, and later at the Vienna conference. And he wanted to have a mood revolving around the CISG. He was, at the first time, he was not thinking of arbitration actually. He was only thinking of promoting uniformity of the CISG. And later arbitrators came and said you should combine it with a procedural part with arbitration, but his focus was on the CISG. Well, as I already said, the CISG is, in my view, a very good compromise of civil law and of common law, and I think the students really get a deep understanding of contract law. And besides that, besides the substantive law that they can better understand after the Wismut, they acquire so many soft skills they never learn at their law schools that are invaluable for any profession afterwards. Well, some of them have been mentioned here. I mean, it's teamwork, it's time management, it's endurance, it's dealing with different cultural backgrounds, adapting to different styles of opposing counsel, different styles of arbitrators, flexibility. So all those are soft skills. Nobody learns at law school, that we should learn at law school actually, but that will equip them with the characteristics they need as an international lawyer or arbitrator.
Yeah, that information about the mood being focused at the beginning or intended to only cover CISG is unique, I guess. It was not very well known, and it looks like a trivia question for Muritz. Yeah. Yeah. Now, you've been involved in the Bismuth since many years. How do you see your role in mentoring the Bismuths for the next years?
Well, I've been, indeed, I think I have been here in Vienna for the second Wismut, sending a team from Basel University before any Swiss universities knew anything about the Wismut. And, well, I think we all should participate in the competition. We should try to participate probably in person, but also remotely in as many pre-moods as is possible. And we should be open. I always get requests, I don't know, 10 or 20 requests for remote practice sessions that I do with teams from around the world. Especially the Indians are very keen on getting practice sessions with me. You should do that, but you should also participate in many of the other endeavors that are around, like the MAA mentorship program, and like, for example, the program Africa in the Mood, where many leading practitioners engage in giving lessons and doing practice moods and the like. So I think that is very important to encourage young people and to be present for them, yes.
Yes, and out of time, regrettably. But let me ask you a last question related to what you just said, diversity. Diversity in arbitration, access to not only arbitration and uniform law, but also to these educational exercises that are so important for everyone, students and lawyers alike. So, and the question is, what progress have you observed in terms of diversity and inclusion, both in the Bismuth, arbitration, and what can do more?
In the Wismut, I think we have reached diversity as to women. We are still struggling with including the global South. So programs like Africa in the Mood are very, very important, and I hope that there will be more. I have already mentioned US aid, and the thing is with the abolishing of US aid, this year 20 teams could not come to the Wismut in Vienna and in Hong Kong, which will harm the whole community, but I think it will harm international commerce, and it will harm the rule of law in the long run. Diversity with women in the Wismut certainly is not a problem. It's different still, I mean, in arbitration. When I entered arbitration, the arbitration world in the 1990s, it was still only old white men. Yeah? So since the 1990s, a lot has changed, and sometimes I sit on panels where we are 2 women out of 3. I've never sat on a panel with 2 other women, actually, where we were 3 women. And the point is, well, regarding diversity with persons from the global south is still to be seen, yeah? There is no diversity, unfortunately, or hardly any. And the higher the amount in controversy, the less women you have. So if there is big money at stake, you have less diversity.
Yes, that's regrettable, and we hope to change that soon. So I'm afraid this is all the time we have for today, but let me thank and recognize Professor Ingeborg Schwenzer for her time here, the answers to these questions. Also, Professor Krina Baltak for the Preserving Perspective project and making this possible, to the MAA, and in particular to ITA, President of the MAA present today, and also to the hosting law firm, Schoher, for their warm hospitality. And thank you to you, of course.
Thank you very much to the ITA, to Professor Schwenzer, to Professor Muñoz and Dr. Baltak. Now we will have our break for about 25-30 minutes, and we will be back for our first panel at 11:15.